Welcome to Infringe at Your Own Risk.
Welcome to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyrights for clients from startups to international companies. I'm Lisa Mosbey, your host, and today we're talking about freedom to operate. Rand will explain what it means, how it works, and how businesses can evaluate whether they're clear to bring a new product to market without stepping into someone else's patent rights. Rand, are you ready to unpack this one with me today?
Absolutely. Good to see you, Lisa.
Thank you so much. Rand, what does freedom to operate mean in practical terms for companies that are prepared to take a product to launch?
So freedom to operate means that you've done at least basic due diligence to make sure that you're not violating somebody else's rights when you release a product. Right? Part of that can be in the trademark context to make sure that you're not, coming up with a name that's too close to somebody else's. But the other is to make sure that your product isn't infringing somebody else's patent, whether a design patent or a utility patent. Nothing like spending millions of dollars creating a product, launching it, and then being promptly served with a patent infringement suit where you spend $1 million, $2 million defending it, only to be told that you can't sell that product anymore. It's difficult to rule out any risk because there's millions of patents out there. So there's, some risk. It could be the material you use. It could be other things, but you can do basic due diligence and say, okay, here's my product. Here are the main features. Am I violating somebody else's patent when I sell this product? Or is there a good argument? And sometimes you aren't, but there's something close and it lets you prepare in advance, right? We know what our argument is. We know why we don't infringe. And in your marketing, you can kind of emphasize the reasons that you don't infringe very subtly, right? So if you have a solenoid and somebody else has a dial, right? And their patent requires a dial. Well, you can work in, this is such great technology because it uses a solenoid, which is better than a dial. Right. Then if you end up in a lawsuit, when you bring in all of that material, the jury sees it and goes, well, look, they improved on what this other guy did. He has a dial, and the better one, it doesn't have a dial. It has a solenoid instead. So that's just an example. So that's something you can do with it. But the real core fundamental is, am I not infringing? And freedom to operate can span a huge array of efforts. It can be a $2,000 or $3,000 search just to find patents in the area that you're practicing in and saying, am I likely to infringe this? Or like some of the pharmaceutical companies do, they will spend literally hundreds of thousands of dollars on a freedom to operate, because if their product catches in the market, it's going to sell hundreds of millions, if not billions of dollars. And you want to make sure that you don't sell $1 billion and then suddenly get sued and have to pay the other party a big chunk of those profits. So it's something that really ought to be done. It doesn't get done nearly as often as it should. And then people are totally surprised when they get sued for infringement.
And Rand, just so I'm clear, how is freedom to operate analysis different than from a patentable or patentability search?
Okay, this is really important because a lot of small inventors confuse the two. In a patentability search, I am asking my search associate who brings me the patents, and then I do the analysis. Is there a point of novelty in this invention that an examiner is likely to say, yes, that's a patentable invention? Okay. So I can find something, yes, there's an improvement. And it may be that, go back to that solenoid analogy, maybe it isn't obvious to use a solenoid instead of the dial. And so that may be the point of novelty. And so I can go back to them and say, yes, this is likely patentable because you've improved it by using this instead of that. And it wouldn't be obvious to trade one for another. I mean, if a solenoid and a dial are basically the same for this function, then you're probably not going to be patentable. But in that analysis, I'm looking, how is your product different than how they've described their product? Okay. I don't focus much on the claims of the patent. And the claims of a patent are like a real estate plat map or whatever. It defines what the invention is. In a freedom to operate opinion, the focus is on those claims. And I'm reading the claims and it's like a checklist. Does my client's product have A and B and C and D? And if every word in that claim is in my client's product, my client infringes that patent. And there's some exceptions where it doesn't have to be word for word, but that's for another episode. So that's the analysis you're going through in a freedom to operate. Does it have it? The irony is you can have a very patentable invention that also infringes someone else's patent, right? If you make an improvement on their product, it may still infringe theirs, but it's an improvement. And I've had cases over my career where we ended up in fights because one party had kind of core technology. The other party patented the improvement that makes it workable. So, invention A invented the basic concept, but it really wasn't marketable. Party B's invention made it marketable. And so now you've got the dilemma. B can't sell it without infringing. A can't sell it without infringing B's patent. And so they end up in a cross-license agreement. And I had one years ago where they ended up in a cross-license agreement. And my client had purchased this technology from a small company. And the first check in the cross-licensing agreement was more than they'd paid for the company. So, yes, they were very happy because the other player, the one who had kind of invented some core technology, was massive. They owned 90+% of the market. And so they were very happy with the cross-licensing agreement because they got to sell product and they got really nice large checks from this other company. So, freedom to operate is important, but sometimes you also realize, hey, we might infringe this patent. Maybe we can go back to the other company and license it. Because often something that infringes somebody else's patent aren't necessarily competitive products. They're using their product for X and you're using your product for Y. And so you can go to company A and say, look, we're doing this. We're not in your market space. We're not competing, but we would be happy to pay you a royalty on our sales if we can continue selling. And they say, hey, that's found money. Sure. Give me that deal. And you go off and you sell your product and you pay a royalty to them. Both parties are happy and you can establish a very productive business on that.
I like it. Rand, I'm wondering when a company is preparing to launch a new product, at what stage should they start thinking about whether they might be infringing someone else's patent?
I think ideally, as soon as you've got a conceptual working model, right? I'm not saying you've actually created it, but I've thought this through and I think this will work. That's the time to start looking and not necessarily doing a really deep dive, but doing a basic clearing search to see what's out there, because sometimes you'll find a problematic patent that you can very easily design around. Right. So I'm in the development stage. Party A has this, and Party A uses this particular chemical compound. Their patent's pretty much limited to that because of the prosecution history. I can use this other chemical compound that will work just as well, and now I'm not infringing their patent. So very easy to do early on as you're developing the product. Much harder to do if you're about to launch and all of a sudden find out, oh, I'm infringing their patent. This is bad. You've spent all that time and money. So doing a freedom to operate early on, even just a basic one, is a good idea, and it can save many times its cost in development of getting too far and then violating somebody's rights and having to retool and remake your product to avoid infringement.
Rand, if somebody has already walked down this path, as you say, and a search identifies patents that look close to the product being developed, How do you evaluate whether it's a real infringement risk versus a superficial? And these are not legal terms, but I'm trying to think, is there any recourse? One thing that you had mentioned is you can go to that other person, let them know that you're not in the same industry, the product's not competing. Are there other options if you find that you're running up against somebody else? Is there a difference between a real infringement versus a superficial simplicity infringement?
Yeah, there is. And it's really common when you deal with um, a lot of smaller companies, but even some large ones, where the patent owner doesn't understand the scope of their patents, right? I mean, I've heard companies say, my patent covers X, and it's like this, and you read the patent and it covers this. It's, I, my patent covers any way of forming ice. I don't think so. Let's go look at your patent, and no, your patent covers forming it in this particular machine in this particular way. Um, and so if you've done that research beforehand, when that complaint comes, you're ready for it. And you can go back. No, here's the 7 reasons why we don't infringe. Goodbye. And then the other advantage of doing the freedom to operate early and finding stuff and having an analysis done in advance is if you do get sued. One of the issues in a patent suit is, was this willful? Are you willfully infringing the patent? And if you are, the damages are trebled, which means it's 3 times the damages. So if you infringe, but you didn't know about their patent, it's $1 million. If you did know about the patent and you chose to infringe anyway, it's $3 million. But if you have an attorney's analysis, a letter that goes through and explains why the attorney doesn't think you infringe, then the chance of getting willfulness goes down dramatically. Because the client says when they're deposed, we had our attorney look at it. The attorney did the analysis. The attorney told us we didn't infringe. Ergo, it's not willful. So it's important to do that in advance of being sued if you know about the patent. Because if you do it after you get sued, it looks like, well, we were just kind of going ahead and then tried to find an attorney who would say we weren't infringing. But if you can find that before you finalize the product and you get that in writing, you're in a much better position in a patent infringement case.
Rand, it always helps us to understand things better when we have a real life example. Is there a chance you could walk us through a company that discovered a potential infringement issue before launch? And how did they adjust? How were they able to design or strategize a way to reduce their risk?
At the extreme, I've had ones where in the process of a patentability opinion, so not even a freedom to operate, but it just in a patentability opinion, the patent that I found was close enough. I said, I'm just going to take a quick look at the claims just to see what they say. And I went through it and if you make this product, you're going to infringe their patent. So the client just decides, don't waste any more money going down that rabbit hole because I'm going to end up getting sued if I do this. So that's one extreme. But at other extremes, we go through and we say, okay, here's the patent. Here's what the steps are, or the elements of the patent. What can we leave out of our product? Right. So I go through and, it claims an elastomeric seal. Well, do we need an elastomeric seal? Maybe yes, maybe no. And sometimes you go through and say, we need all of this stuff, but if we change the way the battery works, or we change the way the tubing is attached, we can get around that. And so when you're developing a product, especially in the medical products field, because it's a very crowded field, there's lots of products, and sometimes a very marginal invention, very minor change can be significant if it improves the way it's used. So I've had cases where the client literally redesigned a product, spent hundreds of thousands of dollars because by attaching it in a different way, they saved 5 cents a piece. Well, when you're selling $1 million a year, 5 cents a piece can become significant. And so, but you've got to go in and you've got to look, okay, how are my competitors doing this? And you've got to look at your own from the patentability side, you've got to look at your own history as well. What have we done and how is this going to be patentable? And then you make sure that the arguments you make for patentability aren't leading you right into an infringement claim on the patents that are owned by somebody else.
And it's something you do throughout, it sounds like. This isn't something that we do at the beginning to check it out and we do it at the end to make sure, okay, we're done. Each step of the invention process, of the creation process, needs to really be considered when it comes to patentability.
There's an old adage in law school: how do you know what the law is until you know the facts? And how do you know which facts are relevant until you know the law? And it's kind of this circle or spiral inward that you do. And that's the same thing with the invention process. As you're working on it, you've got to be analyzing it and say, okay, is this patentable? Is this new thing we're doing patentable? Is it going to get us sued? Okay, no on both. Okay, let's move forward. And you keep refining and you're looking and you're pulling in information. And, I've got clients that I've been representing for 20 plus years. And sometimes I am the institutional knowledge. I've had them come and say, hey, look, we've got this really cool new invention that we're doing. I'm like, that's not new. And they're like, well, what do you mean? I said, you guys made that 20 years ago. They're like, oh, really? Yeah, you did. I did the patent on it. Here's the patent that you got. And now it's out of patent. It's been so long that the patent's expired. But you have things like that happen. So, but it very much is doing it as you go.
You mentioned medical devices. I mean, there's so many medical devices being created. There's so many inventions on a day-to-day basis. But for companies developing new technology in competitive industries like medical devices or maybe consumer products, what ongoing habits help them to stay ahead of infringement risk instead of reacting after the lawsuit is filed?
Good freedom to operate opinions. And keeping up on your competitors, knowing what your competitors' products do, how they do it, is beneficial. Because if the competitor came out with a really similar product, we want to be searching that competitor and looking at all their recent patent filings that we can, whether issued patents or pending applications, and saying, okay, this pending application hasn't issued as a patent. Does it look like the claims are going to read on what we're doing? And also, if there's common inventive subject matter, you can look at how the patent office is treating them versus prior art and say, okay, well, maybe we need to take a different focus because what we thought was patentable, they didn't. The real challenge, it's been eliminated somewhat by the revisions in 2013 to the Patent Act, but you get parallel patents from two different companies that effectively disclose the same invention. And one would get allowed and one would get rejected based on mostly on the whims of the patent examiner. But, you have to look at that and say, okay, well, this one's getting rejected. How strong is my patent? Because mine went through, but my examiner didn't find these other two references. Maybe I need to do a continuation application and submit those references and see how it's going to play out with the examiner. So it's just taking all the data points and connecting them and continuing to build and having your engineering teams understand what's going on in the industry and what the patent landscape looks like.
Rand, thank you so much for unpacking this with me today. I appreciate it.
That's great.
Folks, that's it for today's episode of Infringe at Your Own Risk. If you're preparing to launch a new product or expand into a competitive market, a thoughtful freedom to operate analysis can prevent costly disputes later. To learn more and connect with Rand and his team, visit batemanip.com. And don't forget to like, subscribe to the show, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.